Good afternoon, everybody. I'm Quinn Hochhalter. I'm a 2L student here and a member of North Dakota's Law Review, and I have the pleasure of introducing our next speaker, Josh Swanson, who hails from Maddox, North Dakota, and currently works for Vogel in Fargo. Mr. Swanson is a graduate from both North Dakota State University and from Creighton University School of Law, where he was the lead articles editor for Law Review and served the school's moot court board. Prior to joining Vogel, Mr. Swanson served as a legal clerk for North Dakota's Northwest Judicial District and practiced law in Omaha, Nebraska in one of the largest corporate and estate planning law firms. His primary practice area concerns litigation with particular focus in energy and natural resource law, and his presentation today focuses on the force majeure or act of God clauses in oil and gas lease agreements. We welcome his guidance on how best to protect our mineral-owning clients. Please join me in welcoming Mr. Josh Swanson.
Thanks for the introduction, Quinn. And thank you to the UND Law Review and Law School for having me. It's always an honor and a pleasure to be up here, even though I'm a big NDSU guy. And Mr. Swanson's a little weird. You can call me Josh. I think of my grandpa as Mr. Swanson. So in any event, my practice area is primarily oil and gas, focusing on litigation, and I deal quite a bit in lease disputes. And the area that I wanted to focus on today is one that, as practitioners, we're starting to see quite a bit more of in the field, and that's the force majeure clause. A lot of familiar faces for those of you who took the class I taught up here last fall in oil and gas. It's kind of always a chess game between mineral owners and the operators, the oil companies, with these leases, because you see certain trends that begin to emerge. I know last year and still today, the drilling operations clause in leases and what constitutes drilling operations was an area of quite a bit of litigation and an area that's received quite a bit of focus, and we'll also touch a little bit on that today. But an area I'm starting to see now with different weather events and other things is operators and oil companies pointing to the force majeure clause in a lease when a lease is coming up on expiration or has already expired, saying that that particular clause is something that saves a lease. Force majeure defined. As many of you probably know, a force majeure clause is common in many, many contracts, not just an oil and gas lease. It's an affirmative defense that frees a party from liability, typically because of an extraordinary event beyond the control of either of the parties to the agreement, and in this case, a lease. Why does it matter? It matters because it's a savings clause, right? So typically how a lease works is that it's set up in a primary term and a secondary term. Now, your primary term is typically 3 to 5 years. Right now, it's pretty much 3 years. So what the oil company says to the mineral owner is that we would like to lease your minerals for 3 years. So that lease has a 3-year term, and during that first 3 years, there needs to be one of two things that extends the lease into a second term called the secondary term, right? So you need production, actual oil and gas coming out of the ground, or you need drilling operations. What exactly constitute drilling operations from a mineral owner's perspective is that well bore going into the ground or a physical apparatus to drill, but from the oil company's perspective, what we see quite a bit in court is that the oil companies say, well, hey, look, we've got our permit from the Industrial Commission, and we've staked the well site, so that's drilling. Well, that seems absolutely absurd to me, but I do most of my work for mineral owners, so I'm going to tell the courts it's absurd. And in fact, during our last legislative session, there was a bill in front of the legislature that would actually define drilling operations, because it is the source of so much litigation and consternation between mineral owners and the oil companies. And not surprisingly, that bill got so watered down and convoluted that it was actually defeated. The oil companies have very good attorneys, they have very good lobbyists, and they're very good at what they do, so they're able to defeat that bill. But during that primary term, if there's no drilling operations or production, the lease terminates, it's done. And that's important because it's a lot of money is at stake, right? When you sign an oil lease, if you're a mineral owner, there's typically two payment components to it. One, of course, is the royalty. So for whatever is extracted from the ground, you're going to get, right now, probably about a 20% royalty of that oil and gas. The other end of it is a bonus, okay? So before there's even a drop of oil taken out of the ground, the oil companies will offer the mineral owner a per net acre bonus of anywhere from 2 to 3, and in some cases, if your land is big enough and in an area of production and they really want it, we've seen $4,000 per acre bonuses. So do the math. I mean, let's assume it's a $2,000 per acre bonus, and you own 100 net mineral acres. That's what? I don't have a calculator on me, and I'm terrible at math. Is that 200,000 bucks? I hope so, something like that, right? It's a lot of money anyway. So those are the primary payment components. And if your lease, if there's no production and there's no drilling operations during that 3-year primary term, that means you get to negotiate a new lease. That also means whatever oil company signs you to a new lease is going to have to pay you another bonus. You don't have to do anything for that first bonus. You don't have to do anything for the second one. And that's why it's an area that's being litigated quite a bit, because the oil companies don't want to go back and pay the mineral owner another bonus, and the mineral owner wants the oil companies to pay them a bonus, another bonus, if the lease expires. So if you look at that last point, it's literally the savings clauses. When you have a lease that comes up on expiration, so I think a hypothetical I walk through later here in my presentation, a lease expires, its 3-year term runs on April 1st, 2013, okay? There's no production, and our position as a mineral owner is that there's no operations. No drilling operations have occurred, okay? The oil company is probably going to argue there's drilling operations, but they're also likely to point to several other savings clauses that would save that lease from lapsing, and one of them that we're seeing now is the force majeure clause. Why does it really matter? It's money. Pure and simple, it's money. And I get calls, I probably get a dozen calls per week from folks out in the Bakken in western North Dakota who have a situation just like I explained. Hey, I had a 3-year lease, it expired on March 15th, there's been no production, they haven't done anything out there, how do I get my lease terminated, right? So our first step is to send a demand letter to those oil companies explaining this is why we think your lease is terminated, and then almost all the time the oil company's response to me is, no, you're wrong, this is why our lease is still, this is why it's extended into its secondary term, or this is why it's saved and it hasn't expired. Some of these other savings provisions include the drilling operations clause, where if you're not actually doing production, but if you've got the equipment on site and you're in the process of starting to drill, when the lease is on expiration, that lease isn't typically going to have expired. You have a cessation of production clause, which means that if you are drilling in this, you see this a little bit. I think it used to be more common back when there was just the vertical drilling, but now with horizontals and the technology and the expertise of these oil companies, they know what they're doing. If they're drilling a horizontal well, most of the time they're going to hit oil, and once they hit, that lease is going to be extended indefinitely. But let's say that horizontal well has a problem, right? For whatever technical or geological or mechanical reason, it shuts down. Well, that doesn't mean the lease terminates. Typically, there's a cessation of production clause in the lease that gives those oil companies either 60 or 90 or 120 days to resume operations or to fix the problem, and then their lease is continued. From a mineral owner's perspective, I try to keep that at the shorter end on 60 days. Typically, you'll see 120 days is fairly common. Failure to identify these terms in the lease or to specifically define them can really lead to expensive litigation. It can also lead to a failure to extend a lease. And if you think about it from a practical standpoint, if you're a mineral owner, that makes a lot of sense, right? Because these oil companies are investing tens and hundreds of millions of dollars out there on these wells. And if I were in their shoes, I wouldn't let them go without a fight either. So what we see, if I get 20 calls from mineral owners. They want to sue. They say, our lease is expired, we want to take it to court. So I explained the process that, hey, look, I don't care if you think the facts are cut and dry, the oil company is not going to roll over. So we'll send a demand letter, and they'll probably deny the demand letter, so then our next step would be threatening to put it into suit or putting it into suit. They say, well, let's put it into suit. It's the principle of the matter. By the way, how much do you charge? And I tell them the retainer, and they say, well, let's just send a demand letter and see what happens. And again, I don't fault the oil companies for it. It's a business, but they know the odds that for every 10 people that call up, maybe 2 or 3 get an attorney, maybe 5 get an attorney, maybe 1 or 2 of them has the resources or the wherewithal to pursue that through litigation, because litigation is expensive. Once you file your complaint, you start doing discovery, you start taking depositions, start gearing up for a trial, start making your dispositive motions, a summary judgment motion. We're talking $20,000, $30,000, $40,000, $50,000. And you tell these mineral owners that, and that's a consideration that they have to take into account, because, while I may like mineral owners, I sure as heck don't work for free. So how do you protect yourself, right? Well, the first thing you do, if you're a mineral owner, is you talk to an attorney before you sign the lease. You don't sign the lease, then call me up or another lawyer up and say, this is such a bad lease, and my brothers and sisters are talking to an attorney, and I figured I should too. Well, once you sign on that dotted line, too bad, so sad. There's nothing we can do about it. So the first thing, and I should point out, there's a lot of mineral owners out there that are very sophisticated. They've negotiated leases, and they know what they're doing, and they'll give it right back to the landman who bring leases to them that aren't as favorable as they probably should be. But when they do come to me, the first thing with these clauses is what I try to do is try to work them out of the contract, right? For all you law students out there, what's going to control if there's a dispute in a lease or any contract? And practitioners, what's the first thing that the court is going to look at a contract? The 4 corners of the document, right? They're going to take a look at the contract, and if the court can get out of it by interpreting the contract in the way you think should be interpreted, then you're a step ahead of the ball game rather than trying to litigate an ambiguous term. So for example, get it out. Warranty of title clause is one of them I always ask to get out, where the oil companies ask the mineral owner to warrant title. You ask for that to get out every time, they'll get it out for you. They'll give you a pew clause. But like with the force majeure, I'll try to, if I can't get it out entirely, which I usually don't try to do anymore, I try to define it in such a way where the language seems a little bit innocuous. And I think this is one area where a lot of these oil companies, these leases are a lot of boilerplate language, right? Okay, there's 14 or 15 provisions you take. If you've ever reviewed an oil and gas lease, or several of them, I know a lot of the students I had in class have, you have a lot of the same provisions time and time again. So even when I take a look at them, it can be real easy to read the first few lines and say, well, this spacing pooling clause is the same one I've seen in 1,000 leases. Why am I going to read it again, right? Same thing with like a drilling operations clause. This isn't going to define drilling operations. I've seen this 1,000 times. Why am I going to keep reading? Well, because some leases do have a specific definition of what drilling operations is. And I think with these force majeure clauses, they talk a lot about express and implied covenants in a lease. So what's a covenant? It's a promise, right? The oil company is promising to do something. They're obligated to do something. Well, if you're familiar with oil and gas leases, is an oil company obligated to drill under the lease? No, they're not. It's a condition. There's conditions that they have to satisfy to extend the lease beyond its primary term and into a secondary term. So we'll take a look at 2 common force majeure clauses. And if you get careless with your language and just include covenants from a mineral owner's perspective, that's great for me. If you're going to just put in covenants and not include conditions or weather events, I'm fine with that, and I'm not going to push back. Same with what triggers that force majeure clause. So when you think force majeure clause, and I know the Aukema case against Chesapeake, which we'll talk about up in the Northern District of New York, that deals with government, federal, state law, government order, rule, regulation. Okay, so you think just force majeure, act of God in general, a lot of times you think, fire, flood, hurricane, strike, war. Well, if you have that force majeure clause and it's just limited to a federal or state law, a government order, rule, or regulation, is a blizzard I know Congress is pretty messed up and dysfunctional, but is a blizzard Congress's fault? That's not a government order, rule, law, regulation. That's not the EPA's fault. Same with the acts of the surface owner. So if you get a surface owner who's a real pain and is obstructing access to the property, is any conduct of the surface owner a federal or state law, government order, rule, or regulation? I would say absolutely not. Another thing that I like to try to do in kind of the back and forth with the oil companies is that if they do insist on a broader force majeure clause, that's going to cover, your fires, your labor strikes, your inability to get the equipment and be as broad as a Mack truck. I like to put language in there that says that's fine, but to trigger the force majeure clause, to use that as a defense, you have to provide written notice to the lessee by certified mail within 10 days at this address from when the first occurrence of that force majeure event starts. So what's going to happen a lot of times? If they don't go back and read that lease or have someone who's very cognizant of what they're doing, they might not send that notice within 10 days, and then you can go to court and say, hey, look, Your Honor, this force majeure clause is here, but by the very language of this contract, they had 10 days to send written notice to my clients. They didn't do that. It's not applicable. The language of the lease controls. If there's one thing that you take away from my presentation today, that would be it. The language of the lease is going to control, and it's going to be the first thing that the court looks to. So the key is, with force majeure, like any other lease provision, what does the contract say? How is the force majeure clause defined in the lease? The Eglin versus Continental Resources case, this is one of the kind of landmark, I think, cases in oil and gas litigation in North Dakota. Just because as practitioners, I cited for about 18 different things. There's a lot of really good law in there. And one of them is the same general rules of contract interpretation govern the interpretation of oil and gas leases. So here's our first force majeure clause, right? So take a quick minute here to read that. Right, this is the one that I talked about a minute ago, that all express or implied covenants. So when you read these, think of the key terms, right? Just like you're reading any other contract or document, what are the key terms? What's going to matter? All express or implied covenants, right? Covenants is a big word. Be subject to what? Federal, state law, executive orders, rules, regulations, and then this lease should not terminate for failure to abide by or to achieve a covenant if your compliance is prevented by, said law or order. Okay, so this is the first one. Here's the second one. Let me take a minute to look at that. Now this one's quite a bit different. This one says that the party's performance under the agreement is subject to acts of God, war, government regulation, terrorism, disaster, strikes, civil disorder, failure to obtain labor or materials, or any other emergency beyond the party's control, making it inadvisable, illegal, etc., to comply with the agreement. For you practitioners out in the audience and for you law students, this is how litigators make a living, right? Because there's so many ways to interpret this. Okay, what's a disaster, right? There's no statutory provision that I'm aware of that defines disaster in the Century Code. Failure to obtain labor or materials. Well, what if I'm the oil company, right? And I know my lease is coming up on expiration on April 15th, 2013. And it's March 1st, and I don't have a drilling rig lined up. And we have about, 200 rigs in the state right now? So if you're getting with, a month or a few weeks left before that lease expires and you don't have a drilling rig lined up, if I'm the attorney for the mineral owner, I say that's your own damn fault. That was your lack of diligence that caused that problem. On the other side of it, if I'm the attorney for the oil company, I say, we were unable to get labor or materials. We tried, Your Honor. We made a good faith attempt. Here are our logs and records. We tried to call the company. We couldn't get a rig. You know it's a problem. We've invested this money. Give us a break. And that's just as good of an argument. Okay? Then you have any other emergency beyond the party's control. What does that mean? Right? What's any other emergency beyond the party's control? I don't know. Is a blizzard a disaster? Is that an emergency beyond the party's control? There's other factors we'll talk about in a little bit. Foreseeability plays into it a little bit, and so does the actions and the due diligence of the operator. But I would say this force majeure clause right here is big enough to drive a Mack truck through. And at a very minimum, if you file a motion for summary judgment, what's a judge going to say about a clause like this? With all these, is a blizzard a disaster? He's going to say it's a question of fact, right? Or he or she could very well say it's a question of fact. So from the mineral owner's perspective, you might have a good summary judgment argument, but the easiest thing to do when you're opposing a summary judgment motion is what? It's a question of fact, Your Honor, and it must be viewed in the light most favorable to us. You don't want to get reversed on appeal. This thing has to go to court. So then from your client's perspective, if you're the one drafting the lease, if you let a clause like that in there and it goes to litigation, part of that's on you for not spotting that. I mean, if you've tried to negotiate it, the oil company said, no, this is what we want. I mean, that does happen. That happens all the time, where I want certain language. Oil company says, no, this is a lease, take it or leave it. So then you tell your client, hey, look, these are the options. You can sign it, the payment terms are good, but here are the potential problems down the road. If this happens, this is what you could be looking at. Now, this is that same force majeure clause, the one with the covenants, and I've outlined or underlined the key terms there. And so when you have something as kind of innocuous as a covenant, well, if you take a look at it at first blush, okay, all express or implied covenants, you have a situation where the operator can't get out to their rig for 2 months. So let's go back to last winter where it was just, blizzard every month of the year almost. Roads are impassable. We're getting 10, 15, 20 inches of snow. You can't get out to some of these rigs in the middle of nowhere. But would that apply to covenants? I would say probably not. That's my position. And I'd also say that a blizzard or a flood or an act of terrorism is not a federal, even though, it's so fun to pick on Congress, right? Even though Congress might seem like they're engaging in acts of terrorism, shutting it down. No. That's not the federal or state law, executive order, rule, or regulation. Versus this one that we've talked about, which is broad enough to, if not drive a Mack truck through, if you're the oil company, at a minimum, you're going to survive a summary judgment motion most likely. So, of course, we kind of talked about it already, but which of these force majeure clauses is better for the mineral owner? It's going to be that first one without a doubt. And for the lessee, the oil company, this force majeure clause is going to be a lot better for them, right? And for the same reasons we've just talked about. So let's walk through a hypothetical. Now, the primary term of the lease lapsed April 15th, 2013. So what that probably means, most leases now are for a 3-year primary term. So the lease would have been signed or executed, dated April 15, 2010. Okay, so in 3 years, to extend that primary term that allows the oil company to hold that lease beyond the primary term, you need the two things, right? You need production or you need drilling operations. Okay, in most of these cases, there's no question that production hasn't occurred. You can't really dispute production, can you? Either you're pumping oil out of the ground or you're not. And if you have production, you're certainly going to have drilling operations, or you're going to have your continuous operations clause that are going to be applicable. So here's the claim. The oil company says the extreme and prolonged winter weather conditions that we had last spring on western North Dakota, or the flooding, go back to the flooding in Minot in the spring of 2011 when we had all the bad flooding out there. Okay, so we can use that example too, where some roads they're literally impassable unless you have a boat to get out there to these rigs, which happened in some cases. Okay, so the oil company says that those conditions, that wintry weather or those flooding conditions prevented timely operation. So, hey, look, Your Honor, we had a good faith intent to do this. I mean, you can see we called this rig company, we had all this lined up, but we shouldn't have to put our equipment on a flooded well pad, or we shouldn't have to put the lives of our employees in danger to go start drilling this well, right? Force majeure, it was a disaster. Okay, so now take a look. Thinking about that, take a look at these two force majeure clauses side by side, right? So the first one, I would say that that's a summary judgment motion right there. You're talking about covenants and production or drilling operations. That's not a covenant. I would say that's a condition. So my first argument in that summary judgment brief would be, Your Honor, we're not even talking about a covenant, right? We're talking about a condition. You know, the thereafter clause and that addendum clause requiring production or drilling ops, those are conditions. They didn't satisfy those conditions. And they're certainly not covenants, right? Because the case law is pretty clear. They don't have an obligation to drill. They just have the right to come onto your land, explore, etc. So that's the first thing I'd point to. I'd say we're not even talking about covenants. This force majeure clause shouldn't apply. The next argument I'd make is, Your Honor, even if it were covenants, even if we concede to say, yes, these terrible weather conditions, the production and drilling ops were covenants of the lease, well, weather conditions aren't federal and state laws, executive orders, rules, or regulations. So there's no way. I mean, I can't see this, given those facts, and I can't see the first force majeure clause applying or even creating a question of fact. I think matter of contract interpretation there, the four corners of the document, that's a matter of law that lends itself to summary judgment. But then take a look at the second one. If I'm the oil company, I say this was a disaster, right? And there's probably been federal disaster relief, like the blizzard we just had down in South Dakota, where all those cattle were killed. There's probably going to be state disaster relief for those counties. There's probably going to be federal disaster relief for those counties. So I tell the court, look, Your Honor, this has been declared a federal disaster area. If this isn't a disaster, what is? The state and government is saying it's a disaster area. And the next thing, failure or other emergency beyond the party's control. So you have at least two things in there to point to say, Your Honor, at a minimum, this is a question of fact and is not appropriate for summary judgment. And I would argue in those cases, there's, flip a coin and the ultimate outcome, whether or not that would be a disaster or not. But failing to define terms, and it's not just with force majeure clauses, the same as with drilling ops. I mean, any clause. If you don't define a term or at least try to, this is how a lot of this lease litigation ends up in court. Because the leases, they're boilerplate and they really don't have any good definitions, which if you're the oil company, that's, from my perspective, that's good for them. They have the resources to fight it. But a lot of these mineral owners, they don't. And these oil companies are used to litigation. These mineral owners, not that it's right or wrong either way. I mean, litigation is a big deal for people. We do it. It's a part of what we do every day. But for especially those practitioners out there and you law students, I mean, you're going to see what we do every day. I mean, that's a huge deal in these people's lives. It's a lot of stress. It's a lot to deal with. And so for them, it's something that I would argue has a greater effect on them than on the oil companies. So if you have the second one in there, at a minimum, they're probably looking to go to trial. And if it goes to trial, by the time you file the complaint, do all your discovery, your clients are not only spending, tens, if not hundreds of thousands of dollars, but their land, their lease there that they're trying to have terminated and forfeited, that's a 2-year process, at a minimum probably, if it gets taken through litigation. So here we have the analysis of the example 1, those key words, the triggering events, the law, orders, rules, regs. That's why that language is so critical in a lease. You have production and drilling ops covenants. And there's the San Mateo case, which, in fact, I've just started citing it in briefs. And that says that the production and drilling ops, those are conditions. Not covenants, those are conditions. And in fact, they've got great language saying, and this is from the case, appellants, which would be the oil companies, simply assume that the force majeure clause applies to the conditions in the addendum clause, even though the force majeure clause itself expressly suspends only the lessee's obligations a term normally used to refer to lease covenants. Lease provisions are either covenants or conditions. A covenant is a promise to do or refrain from doing a specific act. A condition is a qualification to the party's obligations. If it occurs, the interest is terminated or enlarged. So in this San Mateo case, we were looking at the force majeure clause is almost verbatim from that first example. The court goes on to say, when I say language is so critical, I mean, that's gospel. In oil and gas litigation, that is absolutely gospel. If the lessee wishes to preclude a possible termination of their valuable interest for unavoidable failure to strictly comply with the conditions precedent, so production or drilling ops, to continuation of their estate, then care in drafting should be taken to ensure that the language of the force majeure clause covers contingencies which affect conditions as well as covenants implied or expressed. And here's the great part. This is a read between the lines, right, where the judge kind of slaps around the attorney is arguing for the oil company here. Careless drafting might nullify the effectiveness of the clause as a device for preventing the expiration of the lease for failure to comply with the conditions or limitation of the typical addendum clause. And that's something, before I had a case come up recently, before I dealt with it or looked at it, I really didn't think anything of it, because if these leases have so many clauses and we hadn't been dealing with it, we'd been dealing a lot with what is the definition of drilling operations. So you start nailing it down, you take a look at this, the force majeure clause, and say that the first thought when I looked at it in my mind was it's their own fault. Their lack of diligence led to the expiration of the lease. And I read through the language again and thought, wait a minute, drilling ops and production aren't covenants. That's the first place you got to start, is with the language. So that was the first argument. Second argument, again, went back to language that the surface owner obstructing access, while that might be a bad thing, and it's not the fault of the oil company, it's not a federal and state law, executive order, rule, or regulation, right? Now, some of the guiding principles before we get to kind of the application of the second one, although you might not think it, because in my experience has been, and some of you practitioners who deal in it, you might disagree, but my perspective is, having clerked for the judges in the Northwest District and dealt quite a bit in this litigation for the last 3 years, that the benefit of the doubt is generally going to go to the oil company. And I've used that before too. I had a case where the mineral owner sued us for breach of the implied covenants. So the other goofy thing about leases is that you have certain obligations in a lease, right? And in most areas of law, if something's not in the contract, you can't go to the court and say, well, Your Honor, this was implied in the contract. We didn't write it down, we didn't agree to it, but it was implied in the contract. Well, in oil and gas leases, there are certain implied covenants in the lease. And in this particular case, I represented the oil company, and a mineral owner sued. One of their first arguments was there was a cessation of production, so the well was offline for like 63 days. And the clause in the lease said, they have 60 days. If there's a cessation of production, if they resume in 60 days, the lease is saved. Okay? So I figured, well, it's 63 days, that's close. Maybe the court will give it to us. So my first argument to the court was, responding to the mineral owner's position, was, Your Honor, it's 60 days. Or are you kidding me? They had ordered the parts for a workover rig. Here's the work order. Here's a shipping thing. Here's an affidavit saying, there was a delay in getting them the parts. Are you going to say this lease that the oil company has spent, X million dollars on is forfeited because they ordered parts and they were in the process of fixing it? They just got there 3 days late? Well, according to the lease, that's probably what should have happened, but the judge said they had a good faith intent. They had everything going up there, so the judge actually granted us summary judgment on that particular argument. And the other end of it with these implied covenants is whether it's a reasonably prudent operator would have done more to drill, which is a whole separate issue, which is a question of fact. But the force, I guess, kind of coming back to where I started, generally in oil and gas litigation, the courts are going to do that because they know there's a lot of money invested. And there are a lot of mineral owners, and I've had a lot of them call me, and I've filed a lot of claims. There's a lot of money involved, so I'm not disparaging one side or the other. But if you have an argument where you can get out of a lease as a mineral owner and sign another lease for $1 million or even $100,000, more power to you. I'd probably do it if I was in that situation too. But they're using different claims kind of. I think some of them are in good faith. I think some of this implied covenant stuff maybe goes overboard, but it's certainly a colorable claim under our law. With that said, the courts a lot of times are reluctant to grant summary judgment. Maybe you take it to trial and you win, but they're reluctant to grant summary judgment. Force majeure cases are a whole different beast, I think, in oil and gas litigation, where the benefit seems to go to the mineral owner instead of the oil company if there's an ambiguity in the contract language. Like any defense, the burden is on the party asserting the defense, right? So in this situation, the burden would be on the oil company to invoke the force majeure clause. The purpose of the force majeure clause, well, it's what we've been talking about, to address unforeseen contingencies that come up and that make compliance with the lease or any contract impossible. And that's a key word. Not impractical, not uneconomical, impossible. In the Aukema or Aukema case out in New York with Chesapeake, the court really hit on that, talking, and we'll get to that in a minute, talking about economically viable, impractical versus impossible. And I think that's another reason probably why the force majeure clause tends to tip in the mineral owner's favor, is because it's usually seen as an impossible event. But again, if you don't define it and nail it down, that's still a question of fact. So you might still win, but you're probably still going to court over it. That's why I say interpret it narrowly, not a Mack truck, but don't let it be a Mack truck if you can help it, right? So if you have the choice between the two, obviously the first one's better if you're the mineral owner. The second one is better if you're the operator. If you're in a situation where you have an oil company, and sometimes they'll just say take it or leave it. Some of them will negotiate. That's their decision. They're paying the money for the lease. I have no problem with that. Some of them will say take it or leave it. We're not going to adjust anything. If you don't like it, don't sign it, go non-consent. Some of them will work with you if they want it bad enough and say, oh yeah, we'll strike that, we'll strike this. So if you can knock out some of those terms, do it, just don't let it slide. Because language in a lease, even the most seemingly innocuous language, is a big deal. So now we get to the second example, right? Same facts. We've got a primary term of the lease that lapsed April 15. We have no production. We're arguing there's no drilling operations. The oil company is saying, well, we've built an access road. We've got some storage tanks out there. We've made arrangements for a rig to be on site. We've staked the well site, and we've got our permit. So that's a toss-up question. We have no production, we say no operations, and they point to the force majeure clause. In this situation, instead of this language on the left side, we're dealing with the language on the right side with the disaster, other emergencies beyond the party's control. So there's your key language right there. That's how litigators make their money. Because you can argue it. I think there's an argument to be made for it both ways. It's not as black and white, and I think it might go beyond the four corners of the contract. Foreseeability does get to be an issue, right? And that's one of the arguments I'd make to the court, is that, hey, look, they contracted. The intent when they signed this lease, they're sophisticated operators. They do business in North Dakota. What can happen in North Dakota in every month of the year? 10 inches of snow, right? Maybe not July or August, but we've had snow in June. We've certainly had blizzards before in March, April, and May. I remember watching the Masters last spring, and we had 1.5 feet of snow in Fargo during the Masters. So one of the arguments is, well, it's foreseeable. How is this an unforeseen event? They knew that there was a possibility of this weather, right? They delayed on getting their stuff out there. The lease expired. That's their problem, not the mineral owners. Okay. So to get into the case study, and this is the big one, because in North Dakota, where we're seeing it right now is surface owner obstruction. I know it's been brought up in the flood cases where there's a bunch of water, but this is the big one because this deals with the moratorium on fracking. And this case is out of the Northern District of New York. What do we have up in the Northern District of New York and Pennsylvania, in that area of the country? We have the Marcellus Shale, right? And they rely on fracking up there just like we do here to get that petrol out of the ground. So the issue in this case, and this is a 2012 case, this just came out, I think this is last November, late November when this came out, so this decision's not even a year old. Does New York's moratorium on fracking qualify as a government rule, order, or regulation that triggered the force majeure clause that saved a bunch of leases from expiring? Okay, now if there was ever a case for a force majeure clause that involved a government rule, order, or regulation, a moratorium on fracking, I mean, just kind of your gut sense, or the first thing I thought of when I saw this case was, well, yeah, a force majeure clause would apply, right? How many of you would agree? First blush, raise your hands. Yeah, a little more than half of you? Absolutely, absolutely. The government, the state of New York, came down with a moratorium that said you can't frack. If that's not a government rule, order, or regulation, what is, right? Well, not so fast. So going through the areas of law, everything we just talked about was what the New York court did. They went through the force majeure as an event beyond the control of the parties that prevented compliance with the contract terms and that can excuse non-performance. When interpreting a contract, what controls? The party's intent controls. Okay, so we're not inventing new law. We're not going over anything new here. The best evidence of the party's intent is what? The contract itself. It's the four corners. Okay? The party invoking force majeure has the burden to establish it. They went down this in order. I took these right from the head notes of the case. So this isn't my brilliant analysis. This is from the case. This is the order they went through. So they started top left to work their way down. Okay, then they get to the big one. Mere impracticality or unanticipated difficulty is not enough to excuse performance. So you hear that, but you kind of shake your head a little bit thinking, right? Mere impracticality or difficulty. The state said we can't do this. They won't give us a permit for horizontal fracking. So how are we going to drill? How is it impractical? It's impossible, right? Court says then, force majeure clause must include the specific event that is claimed to have prevented performance. So another red flag, if you're drafting, I think what's going to happen because of this Aukema case is you're going to see a lot of leases that are coming up. What you should see, it might take some time to get there, but now the oil companies have very good attorneys. They're very good at what they do. And the oil companies pay them a lot of money. If I'm reading this case and I work for an EOG or a Continental or a Hess, every new lease I have is not only going to include a government order, rule, law, regulation, it's going to say in very clear language, if anybody puts a moratorium, prohibition, ban, difficulty, throw 15 words to say the same thing in there. If that happens, that's force majeure, and we're saved from complying with the lease until that event is removed. So here are the facts. The plaintiffs brought a DECA action, declaratory judgment, seeking a declaration from the court that their lease is expired at the conclusion of the primary term and were not extended by the force majeure clause. Now in this case, the New York governor directed their Department of Environmental Conservation to conduct a study because fracking, the horizontal fracking, and that's relatively new. And so you hear a lot about, well, what are its environmental impacts? Well, that's what the governor said. That's why he ordered this EIS, this environmental impact study, is what is it doing to the groundwater, infrastructure, the impact of the trucking, all that stuff. That's why they wanted the study. So they did it, and while they did the study, the department stopped processing permit applications for horizontal wells pending completion of the study, or the operators themselves, they could conduct a site-specific environmental impact study, and so long as they address those same concerns that the state of New York had pointed out, that would be fine. Chesapeake argues that the directive constituted a moratorium that effectively brought natural gas development in New York to a screeching halt. Again, I would agree with that. I would say that it's absolutely what it did. That's not what the court said, though. The court said that the directive did not prevent the lessee from performing under the terms of the lease. But just think about that for a minute. It didn't prevent them from complying with the terms of the lease. Well, how are they going to drill? If they can't do horizontal drilling, if they can't get the permit, how are they going to comply with the terms of the lease? Leases didn't say they have to drill horizontally. The plaintiffs leased defendants access to the premises for a set period of time and granted them the right to explore for natural gas and oil. And in the event that they discovered gas or oil during the primary term and subsequently drilled or produced, the defendants were obligated to pay royalties. Okay, that's true. But the defendants did not have an obligation to drill, and the invocation of the force majeure to relieve them for all their contractual duties is unnecessary. And that gets back to that covenant language, because they don't have to drill. If you sign a lease that doesn't obligate the oil company, just like the court says that's true, that doesn't obligate them to drill or produce. The directive, the moratorium, did not frustrate the purpose of the lease, which was to explore, drill, and produce. They could still do that. They could still explore. But they went further and said they didn't have to do horizontal drilling. They could still do the vertical drilling. And that gets back to the impractical and economical. Court says force majeure doesn't mean that you're excused when performance is uneconomical. It means you're excused when it's impossible. The directive put a hold on the horizontal drilling, but the permits for the conventional drilling and vertical, those were still being issued. The only thing the defendants couldn't do during the primary term was drill horizontally. So the lease didn't limit their ability to drill. It just limited their ability to do a certain kind of drilling, even though that's the drilling everyone's doing, even though that's the drilling that's commercially viable. Court didn't care. It said they could still do drilling. And the bottom one, lessees did not contract for guaranteed production of oil and gas. They contracted for access and exploration and the right to drill for a set period of time. The lesson? In anything with oil and gas with the lease, careful drafting is always critical. That's the first rule. Spot the issues beforehand. And when you're a practitioner, I'm not kidding. I've probably reviewed a couple hundred leases this year. And they're almost always the same. It's the same boilerplate, it's the same language, but you still need to go through every one line by line, because if you don't, it could come back and bite you. And address them beforehand. If you can contract a provision out of there, you should try to do it. If you can't contract it out of there, you can get a rider or an amendment to the lease saying that this is what X term means, this is what drilling operations mean. Drilling operations requires actual drilling, requires a hole in the ground, not just site prep. Force majeure clause. If I'm the oil company now, every lease I have is going to include language that says any ban, moratorium, prohibition, any difficulty. There's a bunch of cows that get in the way of our horizontal drilling. That counts. That's force majeure. Address them, because the failure to do it can really mean a lot of money on the back end. So you try to get it out of the lease. That's all I have. I'm more than welcome to answer or take any of your questions if you have any. That's a good question. Not to be evasive, but I think it's going to be a case-by-case type of decision. I think, if I'm the mineral owner, I obviously cite to the Aukema case or Aukema. I cite to that and say, that's not enough. You didn't contract for a guarantee. Find another way. And in a lot of those situations, that's probably the only way for the operator to get on the land, and they're incredibly limited. They can't get on there. So I would agree that that's a good force majeure argument, but I don't know. Our courts haven't ruled on it yet, so I don't know. I can't really tell you which way they'd go on it. Your guess would be as good as mine. That's a good question too. That's where a lot of this is going too. Like out in Colorado, I know I talked with a few of you about this when I spoke to the energy law group here last Thursday. A lot of townships and counties are putting in different moratoriums like that. Pennsylvania has it too. They're starting to do it. Colorado's doing it. Areas in western North Dakota, a lot of municipal township regulations that are coming about that are making things more difficult for the operator. But I'm not, I don't think there is a case in North Dakota that addresses that yet, but I think we'll probably have one pretty quick. That's another end of it. And I told the kids I taught, with oil and gas law, there's not a lot of case law in North Dakota on a lot of these areas. So it lends itself to litigation and uncertainty where, we settled a case last spring. We had a decent argument. The oil company had a decent argument. But because there was really no black and white case law on it, the court could have went either way, so it's a zero-sum game. One of us was going to get everything probably. The other side was going to get nothing. So that's a lot of risk for both sides. So I think part of the reason that we don't have case law coming out in these areas. And every time, the North Dakota Supreme Court, when they release opinions, practitioners, you get those emails, 20 cases at a time. The first thing I do is I scour for oil and gas cases, and you've got the family law divorce cases and the criminal cases that are summarily affirmed, and there's not a lot of stuff coming out on oil and gas that, as much as you think there would be for these disputes, I think part of that has to do with the fact there is uncertainty. A lot of the cases are getting settled. I think generally in North Dakota, the regulatory environment and kind of the mindset tends to be, and I don't want to get political or anything, but I think it tends to be more pro-development than maybe areas like New York, where not that our judges aren't sensitive to environmental impacts, I just think that New York is different than North Dakota, right? And I think when we see a case like this, a force majeure type thing, the smart attorney on it is going to look for good facts, a good test case, because there's no cases out there on it. So if I'm the mineral owner and I have a force majeure issue and I have an expressed or implied covenant, so if I've got a oil company fighting me, that's my language, and we're talking about something that's not a covenant or a moratorium or anything, then that's a great case for, if you get over, if the district court disagrees with you, that's a great case to appeal. That's a great test case because those facts certainly lend themselves to a more favorable interpretation. Whereas if I'm the operator, those facts are going to be more favorable to me. So I think part of it might come down to whether you see language like this, language like that. But at the same time, with that said, with the Aukema case, to me, my first blush when I saw that was, how can they not say this is force majeure? Of course, right, when they said, they didn't contract for it. They still had the ability to drill. So unless I would expect now with a lot of the leases that I would see from a mineral owner's perspective is going to have language that's going to mention, specifically incorporate these kind of things into it. But if not, again, your guess would be as good as mine, flip a coin, which is why I think a lot of this, it's frustrating because it's pretty, it's great to have the case law on point, but when and I'm sure a lot of you practitioners doing oil and gas, the same cases, Anderson v. Hess, the Murphy case, those cases, they come up over and over with regards to oil and gas. Eglin versus Continental, the one that I cited in here, you see that all the time. Forum, all those cases about the implied covenants from the mid-90s, time and time again, just because we don't have a lot of case law on it. So I cite a ton to Texas, Louisiana, Oklahoma law where there's oil and gas. Jurisdictions that have had law around for a while. Question, boy. Nope. Well, again, thank you to the law review. I think this is a fantastic thing that you guys are doing. I know you put in a lot of hard work, and thanks for having me here.